Hello, everyone, and welcome to our One Big Beautiful webinar today. I'm Tom Warren. I am the co-head of Evershed Sutherland's Global Energy Team, and we're presenting today the last in our series of Season 4 of Energy Transition webinars. Today, we're going to be focusing on the One Big Beautiful Bill Act and the significant changes that it is making to renewable energy tax credits and other tax credits. I'm joined today by Wes Shoemaker, Frank Comparetto, and Bridget O'Donoghue. We're going to start off with an overview of the bill and what has changed. Then we're going to follow on with a discussion between Wes and Frank and me regarding some of the changes that have been made and the effects on the markets. And I'm going to turn it over to Wes to lead us off.
Thanks, Tom. Well, after much anticipation and multiple legislative proposals, President Trump signed into law his One Big Beautiful Bill earlier this month on July 4th. During his 2024 campaign, President Trump specifically targeted the energy tax benefits under the Inflation Reduction Act, and he suggested that he would eliminate those benefits on his first day in office. In particular, he was critical of tax credit benefits for solar and wind projects and for electric vehicles. While the new law doesn't repeal the IRA, and in fact, it retains much of the architecture of the IRA in relation to the energy tax credits, it does impose new limits and due diligence obligations for projects that begin construction after 2024. Again, to repeat that point, these new rules apply to projects that begin construction after 2024. Under the new rules, tax credit benefits for certain technologies, including wind, solar, and hydrogen, are subject to accelerated phase-outs. The law also includes new Foreign Entity of Concern, or FEOC rules, which are incorporated into several of the tax credit provisions, and they generally limit tax credit benefits for taxpayers or projects that rely on Chinese investment components and certain contractual relationships. Today's webinar will provide a high-level overview of these changes, and we'll discuss commercial considerations for developers and investors in evaluating projects going forward. And with that, I'll turn it over to Bridget to discuss some of the changes in the new law.
Thanks, Wes. As Wes previewed, under the new law, certain credits are going to be subject to an accelerated phase out or even termination. Specifically, solar and wind facilities are going to be required to be placed in service no later than December 31st, 2027 to be eligible for ITCs and PTCs. However, after a last-minute amendment in the Senate, certain facilities are going to be able to avoid the 2027 placement in service requirements. If a facility begins construction prior to July 5th, 2026, then these facilities will be able to continue under the current guidance and will have up to 4 calendar years after beginning construction to be placed in service. So, for example, a facility which begins construction in early March 2026 will have until 2030 to be placed into service and still be eligible for ITCs and PTCs. And as a note, clean hydrogen PTCs are going to terminate for projects which begin construction after December 31st, 2027. And credits for electric vehicles are generally ending in 2025, and credits for electric vehicle charging stations are generally ending in 2026. However, other credits are going to generally continue under the IRA framework with certain modifications. So, for example, credits for energy storage technology, including energy storage technology that is associated with a wind and solar project, are not going to be subject to the accelerated phase-out, nor will ITCs and PTCs related to non-solar and non-wind technologies such as geothermal, biogas, hydroelectric, and nuclear technologies. These technologies, projects which begin construction through 2033, are going to be eligible for ITCs and PTCs with a phase-out beginning for projects starting construction after 2033, with a termination of the credits for projects which begin construction after 2036. Additionally, the carbon and capture and sequestration credit amount had previously been higher for carbon dioxide, which had been sequestered, as opposed to used in enhanced oil recovery or for another commercial use. The new law changes this credit so that all uses are eligible for the same credit amount. So carbon dioxide used in enhanced oil recovery or for other commercial uses will be eligible for the same amount that would previously only able to be claimed for sequestering carbon. The clean fuels credit was previously scheduled to end at the end of 2027, which the new law extended to 2029. And the advanced manufacturing credit will change some of the phase outs, but for the most part remains intact. As Wes previewed, all remaining credits will include some new limitations under the foreign entity of concern rules. So taxpayers will need to consider these new rules when claiming any credit, and we'll discuss these rules further in detail later in the presentation. Finally, generally elective pay and transferability will continue, so the credits will still be able to be monetized. However, the new foreign entity of concern rules will prohibit the transfer of credits to certain identified entities. And previously, the transfer of credits related to solar and wind facilities dominated the market. However, with the new phase outs, we expect these transfers to decline and transfers for other technologies to begin increasing.
Thanks, Bridget. So I think a lot of the focus under the new rules involves the beginning of construction determination, which is a term of art. It's something that's determined for U.S. federal income tax purposes. I think the transition for solar and wind and whether or not they qualify, obviously, as you pointed out, is different depending on when the project begins construction. And as we'll talk about in a little bit, we also have beginning of construction elements that are relevant for purposes of the new FIOC limits. And so I want to turn it over to Frank Comparetto now to give us an overview of the beginning of construction rules.
Thank you, Wes. Historical IRS guidance provides two separate methods for taxpayers to establish beginning of construction. These are the physical work test, which is generally a facts and circumstances determination, and the 5% safe harbor, which is a much more mechanical test. Under the physical work test, construction of energy property begins when physical work of a significant nature begins. This test is actually focused on the nature of the work performed itself, not the amount of the costs that are incurred by the taxpayer. Under the 5% safe harbor, construction of energy property will be considered as having begun if a taxpayer pays or incurs at least 5% of the eligible project costs. However, when costs are paid or incurred is actually based on certain U.S. federal income tax rules, which may differ based on a taxpayer's method of accounting. Accordingly, a taxpayer is not able to simply write a large check up front in order to establish beginning of construction in all cases. In some cases, a taxpayer may actually be required to receive delivery of equipment or components to have incurred these expenses for these purposes. If work is performed by a third party, for example, pursuant to a binding written contract to purchase equipment, there may be opportunities to count the work of that third party as having been done in determining whether construction has begun. Further, once construction begins, whether under the physical work test or the 5% safe harbor, construction must be continuous. This is referred to as the continuity requirement. Although the continuity requirement is generally a facts and circumstances test, it can be typically satisfied if a project is placed in service no more than 4 years after the calendar year in which construction has begun. So these are generally the rules that are in place now for establishing beginning of construction for purposes of ITCs and PTCs. And the Act actually refers to this existing guidance as in place as of January 1, 2025. But this reference, by its terms, really only applies specifically for purposes of applying the new foreign entity of concern rules, which we're going to discuss in more detail briefly in a few minutes. Because of this limited application, Treasury could issue additional guidance on beginning of construction that would further limit the availability of certain tax credits. In fact, President Trump actually signed an executive order just 3 days after signing the bill, instructing Treasury to issue additional guidance within 45 days, which is August 18th, to ensure that policies concerning beginning of construction are not circumvented, including by preventing what he called artificial acceleration or manipulation of eligibility by restricting the broad use of safe harbors unless a substantial portion of a facility has been built. This executive order expressly refers to termination of wind and solar credits. So based on the language in the executive order, we expect changes to the beginning of construction rules, for example, the continuity requirement or the 5% safe harbor, in connection with wind and solar projects.
Thanks, Frank. That's interesting. So it sounds like we could potentially have two different sets of rules, one that would apply for the new FIAC limits and then another that may apply to determine whether or not you fall within the transition rules or not. Is that how you interpret it?
That's right. That's right. Because the foreign entity of concern rules specifically refer to existing guidance, but the other rules are silent as to which guidance applies. And add that to this executive order that came out that expressly mentions wind and solar, it is very possible that we'll have different standards for different types of technology.
That's interesting. And when should we expect the new guidance to be applicable? Typically, when the IRS puts out guidance, it's like this, it would be prospective as opposed to retroactive. What are your thoughts on that?
Yeah. Typically, we would expect it to be prospective. You're right, but it definitely could be retroactive, especially since the order itself phrases this change as having some sort of anti-abuse element. Although that could face legal challenges, it's also possible, like you mentioned, that it could be prospective. And then, with respect to retroactivity, the timing could really be anyone's guess. It could be retroactive to the date of the bill itself. It could be retroactive to the date of the executive order, which was July 7th. It's really anyone's guess at this time.
Thanks, Frank. So, Tom, turning it over to you, is the industry responding to the new law?
Yeah, so far I feel like it's been greeted with some sense of relief, even though the wind and solar tax credits have taken a big hit. There is a significant reduction in uncertainty, and I think it's going to make a lot more projects proceed on an expedited basis. For starters, you have a whole pipeline of projects that have begun construction, at least under the old rules, by the end of 2024, which are unaffected, subject to what you and Frank were just discussing. And that pipeline will definitely get moving. And then there's going to be a strong effort that's already begun to get projects under construction, both for FIAC under the current rules as mandated in the statute, and then for the wind and solar for eligibility purposes by July 5, 2026. So that's going to create a lot of activity, right? The developers are going to work very hard to get under construction under these new rules and to finish by 2027, because then they don't have to worry about the new rules for beginning construction if they're done by 2027. So the developers are really pushing now to get those projects to that point. I really think that this is going to loosen up offtake markets as well. Offtake markets have been pretty stalled lately because of all the uncertainty pending this act. But in addition to the added certainty, there's now a really strong incentive to get these projects done and under contract and placed in service while there's the certainty of getting the tax credits. So there's an incentive for the off takers as well, because they don't want to pay the additional costs that they're going to have to pay for projects that don't meet the credits. So I really think the offtake markets are gonna be unstuck by this. I also expect an uptake in M&A activity. Again, there's a lot of push now to get these projects both under construction and completed, and there's going to be capital required for sure to get those projects completed. And under the new rules, which we're anticipating, there may be more requirements. We expect much more stringent requirements, and that could take additional capital too. So even though there's additional uncertainties, which I think will be addressed in M&A agreements, we'll have new terms and conditions to address those things. I do expect an increase in investments and M&A to push those projects forward. And really, I'm talking about the solar and wind. I also think this eliminates the uncertainty on storage and nuclear and carbon capture. All of those now have until the end of 2023. Storage is going to keep going, but technologies like nuclear and carbon capture, I think, there's been a lot of interest in that, and this really frees up people to go forward with those investments.
Thanks, Tom. Yeah, I think one thing, even for those other technologies that don't have the shorter timeline, I think they'll need to be thinking about the FIAC rules, which we'll get to. But it sounds like for developers, they may have multiple projects in their pipeline, and they're, like you were saying, certain projects may have begun construction before 2024, so those are in the clear and can continue on. But then for those that are post 2024 that begin construction in 2025, given what Frank was saying with the possibility of new guidance, you're basically in a spot where you kind of do whatever you can do, do the best you can, given what you know today, understanding that the guidance, the future guidance may change the analysis, but, you do what you can to begin construction. And then, you kind of wait and see what happens. And you may have certain projects that you're able to get under construction and then certain projects that you can't. And in some cases, your position might be stronger than others. So I think for developers from that perspective, it'll be important to really document to the most extent possible, your analysis for beginning of construction. I think, you'll see people seeking opinions for that, that legal analysis. And then you'll also probably see insurance being used to a large degree to support the beginning of construction. We've seen tax insurance used on renewable energy projects to a large degree over the last several years, and including on beginning of construction. So I would expect that would be an issue that the underwriters would continue to ensure. But then, you're going to also have those projects that you don't get there, you don't accomplish it. And then the question will be, are those projects still viable if you're uncertain that you can place in service by the 2027 deadline? As we have experienced on multiple projects in this industry, oftentimes, there are delays, and in many cases, it's really outside of the control of the developer because of all the regulatory restrictions and requirements and permits, et cetera, that you need. And so I think will put pressure on investors, for projects that that don't meet the beginning of construction in a way that allows them to avoid the accelerated timeline. You're going to have more risk, and then query whether you're going to be able to bring in the capital to develop the project if you're forced to say, I have to, complete the project and place in service by 2027. I guess the other side of that too is that if you are looking at the placement in service, that's another term of art, right? That's not it's not just turning it on. There's more to it than that. It's a term of art for tax purposes, and so you can see projects that don't begin construction that have that shorter deadline, the end of 27, focusing hard on placement in service. And so you'll probably see at that point, developers, looking to their advisors to help them determine, has the project been placed in service or what needs to be done to achieve that result. And then, for those projects that don't meet that deadline, they wouldn't be eligible for credits. And so then, the question would be, is that project still viable at all? I think it's clearly there's strong demand given data centers and other users of power. The demand seems to be increasing. And so the need for the power is there. So, I could see possibly people looking to renegotiate PPAs and things like that, where the credit benefits ultimately aren't available, to try and, make the economics of the project such that it can still proceed. But, I think we'll have to wait and see how that plays out. And then I guess one final point I have is on the transferability. Obviously, for the pre-2025 projects, those don't have to worry, those projects don't need to be concerned with these new rules. And, there's a fairly large pipeline of those projects. And so I think we're still seeing transfers, for projects that began construction before 25. And I think we'll continue to see that. But then at some point, those will taper off. And I think we'll probably see less solar and wind on the transferability side. But then that, potentially gets replaced with other technologies. You could see an increase in the carbon capture credit. That one may be more of a focal point for folks going forward, including under transferability. So I think there's a lot of interesting things, a lot of moving parts. Obviously, people are going to have to do their diligence and do their analysis. And I think it all really starts with the beginning of construction and where is the project in relation to that issue. I think at this point, it's probably good to now turn to the FEOC rules. And again, to provide an overview of those, that's another area where I think, there's going to have to be a significant amount of diligence done by parties involved in these transactions. And so I'll turn it back to Bridget to give us a high-level overview of those rules.
Yes, so as we've alluded to throughout the presentation, the new FEOC rules place significant restrictions on prohibited foreign entities and projects which are constructed with material assistance from a prohibited foreign entity. So prohibited foreign entities are ineligible for all credits which begin in taxable years that start after July 4th, 2025. So as a threshold matter, it's necessary to determine what entity is actually eligible for the credits and confirm that this entity is not considered a prohibited foreign entity under the new law. So the new law introduces several terms, including prohibited foreign entity. and defines prohibited foreign entity as a specified foreign entity or a foreign influenced entity. The definition of specified foreign entity is made by reference to several other statutes, some of which rely on designations from the Secretary of State or Secretary of Defense. So because of this, the definition of specified foreign entity is fluid and subject to change. However, currently, this definition targets entities associated with or controlled by China, Russia, Iran, and North Korea. And because of the energy tax credit area, we expect that entities organized in China, those will have the most relevance to the market. And foreign influenced entities are entities that are not organized in the countries I mentioned earlier. However, they show signs of control by specified foreign entities through certain ownership and management criteria outlined in the new law. Additionally, if an entity enters into contracts under which it makes payments to a specified foreign entity, and the specified foreign entity is then entitled to exercise effective control over such entity's qualified facility, that entity is also considered a foreign influence entity. And we expect more guidance in this area from Treasury. However, effective control under the new law seems to generally mean that the specified foreign entity is able to make key decisions related to the relevant facility. And as you can see, these definitions are very broad and meant to encompass a large number of entities that may or may not have significant ties to China. Additionally, even if the taxpayer itself is not a prohibited foreign entity, its projects may still be ineligible for certain credits. And those credits are the ITC under 48E, the PTC under 45Y, and advanced manufacturing credits for receiving material assistance from a prohibited foreign entity. And facilities which begin construction after December 31st, 2025 are subject to these restrictions for material assistance. So the new law introduces a new concept of the material assistance cost ratio, which is a calculation that determines the percentage of manufactured components, manufactured products, including components that are not attributable to prohibited foreign entities. These are similar to the domestic content adder rules under the IRA, and until new guidance is issued by Treasury, taxpayers are able to rely on the domestic content notices to determine if a product was manufactured domestically. Taxpayers may also receive a certification from a manufacturer confirming that their products are not attributable to a prohibited foreign entity. If a taxpayer's material assistance cost ratio is then less than a threshold percentage outlined in the new law, that means that the project has received material assistance from a prohibited foreign taxpayer and is ineligible for certain tax credits. The new law includes tables with threshold percentages that differ based on the type of facility or component that is that the taxpayer is attempting to claim credits with. And the threshold percentages will increase each year based on when a project begins construction, so that projects which begin construction in later years will need to ensure that less of the manufactured products they use in construction are attributable to a prohibited foreign entity in order to remain credit eligible. Finally, the new law introduces a punitive 10-year recapture period, which begins on the date in which the facility is placed in service. And this is specifically for the Section 48E ITCs. Other credits are not subject to the recapture rule. But generally, if a specified taxpayer makes an applicable payment, there will then be a 100% recapture of Section 48E ITCs. And a specified taxpayer is any taxpayer claiming a Section 48E ITC in tax years which begin after July 4th, 2027, and applicable payments are those which provide effective control to specified foreign entities.
Thanks, Bridget. There are a lot of moving pieces there. I'd say in particular on the definitional pattern, it seems that Congress took a fairly broad approach in the application of these rules through the definitions, as you were describing, you have the the prohibited foreign entity is kind of the overarching term, but then within that you have specified foreign entities, foreign influenced entities, and then that includes entities that are under effective control. So you have multiple standards, and it seems to me that what the intent was there is that they're trying to prevent gamesmanship, where people would structure around these rules, through contracts and how they set up their contractual arrangements or their investments, et cetera. So I think what Congress did here is they took a fairly broad approach, which I think will put pressure on developers and investors, because this will be a very intensive diligence exercise. One, for the developer to first determine, are they caught up in this, so that they don't get the credit in the first place. But then also the investor will have to go behind and do their own analysis on that front. And Tom, what are your thoughts on how investors might approach that issue?
Yeah, I mean, we're definitely gonna have to see some changes from both developers and investors, and really everybody in the chain. For starters, people are going to have to go review even existing contracts to make sure that they don't potentially trip over these rules. And we're going to see more guidance come out, we hope, and give us a little more certainty. But you've got to make sure that you can meet all of these tests, and the rules go into various things in your contract that you can't have that would be given control. So people are going to have to look at that. And then, they're not going to have as much insight as to necessarily all their suppliers' components. And so they're going to need to do both due diligence and get contractual protections against what the content is of all of these components, because that could all end up going to making sure you can meet these thresholds. So you're going to need certifications not only to meet the rules, but to satisfy tax equity investors, to satisfy acquirers, and of course on the investor or acquirer side, you're going to have to do all the same due diligence, because you're going to be potentially the one ultimately needing to meet these tests.
Yeah, I think on the material assistance point, as far as sourcing the components, it's interesting to me that there's a lot of overlap here with the domestic content adder rules, which are from the IRA, as far as how you run the ratio and you look at the manufactured products. I mean, there are several terms that are similar, and even the new rules allow you to rely, at least temporarily, on the domestic content adder guidance. And as we've seen in transactions that have already that we've worked on to date, when you're looking at domestic content, how you categorize things as, is it a manufactured product or not, for example, is not always clean cut or straightforward. There are a lot of nuances with those rules and uncertainty. So I think that's going to be another area where folks will have to really dig in and do analysis on those issues and to get comfortable. And I think, also going back to the tax insurance point, you could see this might be another area where people are using that product to help underwrite this risk. As you were pointing out, having suppliers do certifications certainly will be something that we'll see. That what we've seen in contracts to date, like when looking at domestic content, for example, it's there's often a limit on the indemnity that the supplier will give for that issue, right? They're not going to cover the full credit loss in most cases. Like they might give you some limited amount of indemnity coverage. So I think that'll be something else that'll be important for folks to consider, like when you're getting these certifications, what's really standing behind that as far as your ability to recover if it ends up it ends up being incorrect or you are unreasonable in relying on it. So I think there's a lot of interesting issues here that folks will need to focus on as they continue to work on the contracts for projects going forward. And then I would say, as one final point on the ITC recapture, obviously a 10-year 100% recapture is fairly punitive. That's a long overhang. So you could see when folks are evaluating, is it better to take the ITC or maybe rethink, maybe I should take the PTC on this project if I can avoid that 100% recapture. Just thinking about it from a tax equity investor or for a tax credit buyer under transferability, a 10-year recapture risk is a fairly long period of time that I would expect most investors and buyers to not want to have to endure, given that how much things can change in this industry over a short period of time. So I think that'll be something else that will be interesting to see how that plays out and impacts the market.
All right. Well, thank you, Wes and Frank and Bridget. That concludes our session today. if for anyone who has put questions in the Q&A, we do not have time for the questions, but we will read all of your questions and we will follow up with you to respond to them. So thank you for any questions. Anybody else may feel free to either add questions to Q&A or you should have all our contact information. We also will be sending a recorded version of this to all of you by email, and it will be available to you on our website as well after the session if you want to share it. So thanks to all of you for participating. We welcome any follow-up questions, and we look forward to welcoming you to season 5, which will be coming up soon. Thanks very much.